Well, good morning, everybody, and a very warm welcome to you all, but especially to Lady Sumption and other members of Lord Sumption's family. And can we say a particular thank you to the daughter who bakes the sumptuous cakes, which we enjoy, according to our custom, every year on Lord Sumption's birthday. Now, as you all know, I am a great supporter of diversity in the judiciary and in this court. And we are here today to celebrate the contribution made by someone who is undoubtedly a diversity statistic in his own right. Lord Sumption is the first and so far the only appointment direct to this court from the bar. Indeed, as Lord Phillips remarked when he was sworn in January 2012, he's only the sixth ever such appointment at this level, following the illustrious examples of Lord Macnaghten, Lord Carson, Lord Macmillan, Lord Reid, and Lord Radcliffe. This is, of course, testimony to his stellar performance at the bar, of which no doubt we will hear more anon, Lord Grabiner. Appearing as I am this week in a Star Wars episode in the Gray's Inn Miscellany, I have particularly happy memories of his advocacy in Lucasfilm and Ainsworth, where he sought to persuade us that the stormtrooper's helmet was a sculpture by bringing it into court, I can remember it to this day, in a glass case, while his opponent brought it into court in a sports bag and handed it round so that Lord Phillips could try it on. But he was also a stellar performer as a part-time judge. I recall in particular the Privy Council case of Simon and Helmot on appeal from the Court of Appeal of Guernsey, where Justice of Appeal Sumption had boldly declined to follow Wells and Wells and opted for a discount rate of minus 1.5% for earnings-related losses and minus 0.5% for other losses in calculating future financial loss in personal injury damages. Needless to say, his reasoning was so powerful that the insurer's appeal was dismissed by the Privy Council. In the 7 years that he has been with us, he has given the lead judgment in no less than 75 cases. And in some of those, what started out as a dissent was so powerful in persuading others to change their views that it became the lead judgment. I haven't counted how many of those there are, but I know there are some. He's made a particular contribution in international law and contract law, but I would like to single out three, which show his versatility and which many would regard as making creative developments in the law. In Prest and Petradell, while declining to pierce the corporate veil in financial remedy proceedings between a husband and wife, he managed to find that the properties vested in the husband's companies were in fact beneficially owned by the husband, thus obstructing to some extent the open road and fast car which the Court of Appeal had allowed to a husband wishing to evade his matrimonial responsibilities. In Woodland and Essex County Council, he extended the concept of a non-delegable duty to schools which outsourced the teaching of the national curriculum, in that case swimming, to independent contractors. And in Parking Eye and Bevis, in a joint judgment with Lord Neuberger, he upheld the long-standing doctrine that clauses imposing a penalty for breach of contract are generally unenforceable, but found that the true test of a penalty was whether the impugned provision imposed a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in enforcing the primary contractual obligation. This is particularly interesting because probably the passage most often cited now, and which will continue to be often cited from one of his judgments, will be his well-known summary of the fourfold requirements of the proportionality assessment in Bank Mellat and Her Majesty's Treasury. We don't seem to have precise statistics for the number of cases in which he has dissented, but we know of only 9. Favourite amongst these, or at least my favourite, must be the obscure little case of the Queen on the application of Trail Riders Fellowship and Dorset County Council, which was all about maps. Regulations provided that applicants to modify the definitive map of public rights-of-way had to be accompanied by a map on a scale of not less than 1 to 25,000. The applicants have provided a map derived from the 1 to 50,000 Ordnance Survey map, but blown up to look as if it was 1 to 25,000. As Lord Sumption pithily explained, there might be 2 reasons for this requirement. Quote, "One is because a map on that scale, showing the relevant byway, could be expected to show more of the surrounding detail than a map on a smaller scale. The other is that it was desired to ensure that the map should be visible without unduly straining the eyesight of those using it. In my opinion, it is manifest that the requirement was imposed for the first of those reasons and not for the second." So in his view, it wasn't good enough. Unfortunately, 3 members of the court held that it was. Now, these few examples are enough to show that Lord Sumption has been able to turn his judicial hand and head to almost anything. His versatility in other respects is also legendary. At an early age, he was skilled on snow, water, and in the air. He was an early and very competent skier, water skier, dinghy sailor, and sculler. He passed his light aircraft pilot's license at the age of 19. He may perhaps be a little less skilled on dry land, having been known to announce that a one-way street sign was purely advisory as he drove the wrong way down it. But I hasten to add that that was a long time ago. He still spends a lot of time up ladders, fixing things, from climbing roses to things about the house. And his ingenuity is remarkable. His daughter-in-law remembers how he got the whole family to turn the house upside down looking for his glasses, until he remembered that he put them in the freezer to try and remove some candle wax from them. History does not relate whether that was successful. We shall certainly miss his company at lunch, where his many cultural interests are much in evidence. Many of us are opera lovers like him, but he is the only one who's been able to have an entire opera crew to stay, hire a stage, lighting, print posters and flyers, and have 300 guests enjoy Mozart, Puccini, or Verdi in the hills of the Dordogne. He's even featured himself in black robes and hood, wielding a vast scythe, playing the Grim Reaper in Verdi's Falstaff. The President's appearance today, as Yoda, the little green man from Star Wars, pales into insignificance. All this amply goes to show that, as his family say, he has never been risk-averse in any area of life, and long may he remain that way. Maybe now he will have time to turn his attention to a history of the Dreyfus case, a jump forward of 500 years, but well within his grasp, and we shall look forward to his Wreath lectures next year. Neither of them, those projects, are for the risk-averse. In this court, we shall certainly miss him for all his many memorable qualities, and we look forward to welcoming him back from time to time. Today is au revoir and not adieu. Lord Grabiner.
Thank you, my lady. May it please the court. When thinking about what I might say today, it occurred to me that your lordship's remarkable career has been characterized by one strikingly consistent feature. At every stage of your career, you've made a serious impact, and in each endeavour, you have achieved that impact in double quick time. At Oxford, after 3 years, you inevitably secured a first in history. Upon graduating, you were offered and accepted a fellowship at Magdalen without the usual prerequisite of a doctorate. You remained in that post for just 4 years, but by then had already established yourself as a serious medievalist historian. You then decided to go to the bar, and in taking that decision, you very wisely rejected the firm advice from no less a person than Lord Denning, who told you it would be, and I quote, a big mistake, close quote, for you to go to the bar and that you should, quote, stick to history, end quote. Your pupillage experiences were varied and were not without their challenges. But with a little help from the late Lord Mustill, you found your way to Brick Court Chambers, to Bob Alexander, Nick Phillips, Sidney Kentridge, and others, including Burley, their formidable senior clerk. I still have an image of him in my dreams late at night. I think we all understand how important to your development the Kentridge connection was. You have said of Sidney, and I'm delighted to see that he's with us here this morning, that he served as an inspiration and mentor, a source of encouragement and consolation, a fine tribute to a great man. You took silk just 11 years after being called to the bar. Given the time limit I'm bound by this morning, I won't dwell on your advocacy performances, save to say that they consisted of a succession of what barristers call great cases. At least one of those cases produced a bizarre, indeed perverse judgment, but I must refrain from controversy and leave the whinge stuck in my craw. In relation to another case, I have a fond memory of our conversation at the end of a monumental battle which went all the way from trial to the House of Lords. My clients had alleged 3 fraudulent misrepresentations in the course of a morning's negotiation. The trial judge, who shall remain nameless, rejected the first 2 in point of time, but was satisfied that on the 3rd occasion, the misrepresentation had been made and was indeed made fraudulently. These mixed findings enabled your lordship to attack the 3rd finding in the Court of Appeal and in the House of Lords on the basis that it was inconsistent with the first 2 findings. Happily, justice was done in the end. But as we walked away together along the red carpet on the committee floor of the Lords, you pithily observed that the trial judge hadn't appreciated that the shortest distance between 2 points is a straight line. Spot on. In January 2012, you were duly appointed as a justice of this Supreme Court, directly from the bar, without any senior intervening judicial experience, although you had sat in part-time appointments as a recorder of the Crown Court, as a deputy High Court judge, and as a judge in the Channel Islands. Within living memory, I've only got 2 names rather than your ladyship's 6, but within living memory, only Lord Reed in 1948 and Viscount Radcliffe in 1949 achieved such distinction. Both were advocates of great experience and exceptional talent, and for you to be the 3rd in that trio is a mark of great distinction. And I've also been doing a little bit of research. We've only crossed on one of the cases, and I hope I may be forgiven for making reference to some of them. So in the short passage of 7 years as a justice, you have once again made an impact, and I've looked up a few examples of your judgments in commercial cases. In Preston Petrodel, which is where we cross over, you analysed the vexed question of when the corporate veil may be pierced, and you spelt out the important distinction between what you described as the concealment and evasion principles. Your powerful dissent in Prudential and the Inland Revenue contains a fascinating historical analysis of the origins of and rationale for legal advice privilege. You bring out the point that the privilege depended not on the status of the advisor, for example, as a lawyer or as an accountant, but on the nature of the advice and the circumstances in which it is given. In Virgin Atlantic against premium aircraft interiors, your judgment memorably begins, quote, "In this case, Virgin Atlantic wishes to recover damages exceeding £49 million for the infringement of a patent which does not exist in the form said to have been infringed," end quote. There are no prizes for guessing the result of that case. Suffice to say that a long line of authority which surprisingly would previously have permitted such a claim was duly overruled. Williams and Central Bank of Nigeria is now the leading authority on the interpretation of the special rules disapplying limitation periods for certain claims against trustees and fiduciaries, and in your judgment in that case, you make the distinction between the true and the constructive trustee. In Cavendish Square Holding and Macdessie, you combined with Lord Neuberger in producing the definitive analysis of the rule against penalties. And then finally, so far as these cases are concerned, your judgment in Playboy Club and Banco Nacional analyses the Headley-Byrne duty, in particular whether it is relevant that the ultimate recipient of the information, the casino in that case, might have been the undisclosed principal of Burlington, which was the immediate recipient. As a justice of the Supreme Court, you have not had much time, but as always, you have made your impact. The pity is that just as you are about to reach the age of intellectual maturity, and I speak from personal experience, you are required to retire. Fortunately, the rules permit you to be invited to sit from time to time for another 5 years. But I think it is time the age provisions were amended. The justice system should not be casting out such talent. Aside from the law, you have sustained a serious commitment to your love of history. Amongst other writings, you have published 4 brilliant volumes on the 100 Years' War, and there is one more to come. Across the centuries, you have managed to bring to life, as one commentator has said, and I quote, "The elaborate complexities of financing war fleets in the 14th century, of papal diplomacy, the deliberations of dithering monarchs, battle formations, the minutiae of social upheavals revealed in ancient parish records, all of which are pepper in Sumption's mortar. The overall impression is one of relentless violence. Towns are sacked, peasants massacred, whole regions depopulated by decades of marauding bands and plague outbreaks," end quote. There's enough promise there to encourage many of us actually to read your books. The serious point is that your background as an historian has informed a good deal of your legal thinking, but concurrently for you to have mastered 2 great disciplines is a special achievement. This could only have been done by sheer hard work and extraordinary single-mindedness over a professional lifetime. In this context, I was hugely amused by the distinguished academic historian reviewing one of your books, who observed, apparently in all seriousness, and I quote, "that it was only by leaving the pressures of academic life for the presumably less pressured environment of the law that you were able to write a work of historical scholarship on the scale of your history of the 100 Years' War," end quote. Some academics never cease to amaze me. In your extrajudicial time, you have lectured and written on a variety of topical issues, including book reviews in The Spectator, lectures on appellate advocacy, diversity on the bench, on legal education, on the historian as a judge, and what you call the disunited kingdom, in which you examined the historical relationships between the nations of the British Isles. You also wrote about the 800th anniversary of Magna Carta. You memorably revealed, and to the dismay of many of your listeners, duly destroyed, the mythological proposition that the treaty is the foundation of modern-day democracy. Your best passage, if I may say so, and I'm going to quote it, was this: "I do have a problem with the distortion of history to serve an essentially modern political agenda. Claims like those which I have just cited are high-minded tosh. They represent the worst kind of ahistorical Whiggism. They encapsulate the view mocked a generation ago in a famous essay by Herbert Butterfield that the past can be viewed as an accident-prone, but on the whole, persistent march towards the manifest rightness of our own values," end quote. Nobody else I know could have concocted that splendid piece of writing. It has been announced, as the President has indicated by the BBC, that next year you will be giving the annual Wreath Lectures entitled Limits of the Law and the Decline of Politics. And I would emphasize the decline of politics particularly at the moment. It is perhaps interesting that Lord Radcliffe, to whom I've already referred, delivered the 1951 Wreath Lectures. His subject was Power and the State. We look forward to hearing your lectures. On behalf of the Bar and those of us who have had the privilege and pleasure of spending time with you, I wish you a long, happy and peaceful retirement. Teresa and all your family have thus far been possessed of infinite tolerance, and I am sure they would like to have more of your company. You will also have more time for your love of opera, for the Royal Academy of Music, and for tending your roses in the Dordogne village of Berbiguiere. I also hope that you will give some time to writing. Given the fact of your advanced years, could I suggest that this time you take on a smaller bite size? Maybe the 30 Years' War, or the 7 Years' War, or even the 6-Day War.
Thank you, Lord Grabiner.
Thank you for my part too. When the great piano accompanist Gerald Moore wrote his memoirs at the end of his career, he called it, "Am I Too Loud?" I, for my part, wouldn't dare to ask a rhetorical question like that. Some people might be tempted to answer it. I think that I can detect from some of the President's remarks what her answer would have been. Now, I know that it is bad form to admit to enjoying a public office. Benjamin Disraeli said about being Prime Minister, "We are here for fun." But it doesn't do to agree with him today, especially just at the moment. However, I have enjoyed participating in the work of this court more than I can possibly say. Many people have contributed to that enjoyment. First of all, there are the loyal and skillful staff who work in this building and support the work of the court, the good-humoured judicial support team, the infinitely patient registry staff, the law reporters who point out our howlers and spelling errors, the IT staff, the library, and not least our candid friends, the judicial assistants, who tell us where we went wrong, sometimes after we have given a judgment. Secondly, there are the advocates who appear here, duty-bound to put forward points in which they do not always have complete confidence, in the face of barracking from sceptical judges who set them tight timetables and then do most of the talking themselves. But I would say, as I suspect that most justices leaving this court would say, that the largest contribution to that enjoyment has come from my colleagues. I may not be a natural accompanist, but which of them would claim to be that? We have differences of outlook, as one would expect of any group of 12 intelligent, articulating and opinionated people. But we do not shut ourselves up in intellectual silos, and we don't dig trenches around our positions. There is a real engagement between members of this court. It may not look that way from the outside, but our judgments are collaborative efforts, even when our opinions are divided. A court of final appeal can decide whatever it likes, except when it can't. In a court which specializes in hard cases, it can be quite a struggle to avoid making bad law. I suppose that what I have found most fascinating about this job is observing in myself and in others the perennial tension between the instinct to soften the law's hard edges and the search for a coherent legal principle which may be qualified but can never be discretionary. Of course, none of these tensions appear in the carefully crafted and self-confident judgments in which we express our views as if we had never had the slightest doubts about them. It's all kept well below the surface. So I thought that I might offer to my successors to help them recognise the signs, a short judicial lexicon of telltale phrases, followed by the correct English translation. A multifactorial test. We can do what we like. A common sense approach. We can do what we like. Pragmatic. We can do what we like. Never say never. Next year we can do what we like. Why isn't this in your printed case? Damn it, we can't do what we like after all. I have sat in this place for 7 years, but I leave it with an inevitable sense of work left undone. But as a wise friend said to me a few days ago, you always feel like that whenever you leave, and there are other things to do. So I shall now go back to being an academic historian, which is how I began. Thank you all for your friendship and support, and for coming here this morning.
Thank you very much indeed. Can we give a round of applause? I think, in fact, that we have Lady Sumption to thank for starting the tradition of a round of applause after the swearing in of a new justice. And so it's as only fitting that we should start the tradition of a round of applause after the saying farewell to a justice. Thank you all very much indeed. There is coffee outside in the lobby, and so the court will now adjourn.